So tonight we're going to talk about everything that's related to the law and how that affects accessibility and where the accessibility laws actually came from. Like, what is the thinking behind it? What's the road leading up to it? And how it affects how you build websites and how it affects UX and how you should be thinking about this. So before I dive in, I just want to talk a little bit about a couple future events that we have. So we have tonight, this is part of a series on accessibility. So on Thursday, the 14th of May, we're going to have a session on testing. So a lot of what you're learning tonight, you're going to be able to learn how to apply it practically to your own website. The other thing is on the 21st, this is an international sort of day to raise awareness for accessibility. And we're going to be doing an event jointly with the Dan Marino Foundation, with Magic Leap, to actually, it's going to be a series of different talks that we're going to be doing on Global Accessibility Awareness Day. So look out for those two events that are coming up. They're going to be Thursday nights, 7-ish. I think the GAD one, the one on the 21st, we're going to have to start earlier. This is going to be a little bit longer, but we should have probably about 4 different talks for that. So let me get this out of the way. I'm not a lawyer. I don't even play one on TV. And nothing that I'm putting in this presentation is legal advice. This is kind of to educate yourself, but none of this is, something that you would formally base a decision, a legal decision on. So Joel may have mentioned, that I work with Royal Caribbean. I'm the digital accessibility lead person in Royal Caribbean. So all of the digital apps, all the websites, all the different guest experiences that are digital essentially have to go at some point or another under accessibility review. So it's a pretty large, vast company, and I do my best to keep up with all the different sorts of digital content that we create. So let's dive into the actual subject matter. So those of you who saw the last talk a few weeks ago, let's do a quick refresher in terms of the number of people in the United States with disabilities. And it's a staggering amount if you start talking about the number of people who have a disability and who are either of working age or who are adults over the age of 18. And what you have to think is, it's kind of like those of us who aren't born with a disability usually start out on the right side of this graphic as not having a disability. And there's, it could be a disease, it could be a life event, it could be something that happens that kicks you over to the other side. But as you grow older, the likelihood of your picking up a disability gets higher and higher until, if you're fortunate enough to live to your 90s, the probability of you having a disability at that age is probably about 95% or higher. So it's extremely likely, that as you go through life's journey, you're going to cross over to the other side, which is the pink side. One of the things, and this is really important here, which is the social model of disability. And the social model here is, it's kind of like you have to turn everything upside down and think that the problem is not somebody's physical ability. It's actually society, and it's the barriers that society creates. So for instance, if you're a wheelchair user, stairs are an obstacle for you. But we don't build stairs, for instance, into streets and highways. So we favor cars over humans in wheelchairs. So the social model is really impactful. It's really one that started like in the 60s in England. And it says that essentially we shouldn't be trying to modify people with disabilities to fit the system. Instead, we should be modifying the system to fit the people with disabilities. So a couple real basic concepts from last time. Everybody has the right to live independently. The built world must not have any sort of barriers to keep people from living independently. And as we're going to see as we start getting into ADA and Title III, the digital world is increasingly being considered to be equivalent of that built world. So it just so happens that this year is the 30th anniversary of the Americans with Disabilities Act. So there's a lot to consider. If you think about how far we've come in those 30 years, it's kind of a mixed bag. When it comes to physical spaces and architecture, I'd say we've probably come reasonably far, and new construction is pretty good about following the norms of the ADA. When you get to the digital world, it's an entirely different matter. So from a legal point of view, a lot of the precedents to the ADA were set up with the civil rights movement. And in 1964, when the Civil Rights Act was passed, it no longer was legally possible to discriminate on the basis of race, religion, gender, and a number of different variables. Now, that sort of thinking carried over to thinking about people with disabilities. And so just as you had a civil rights movement, you had a much smaller sort of movement for people trying to get disability rights to happen. And in this picture, what you're seeing a group of people in wheelchairs creating their own curb cuts with hammers, if you can imagine this. So you see the gentleman on the right, and if you look carefully enough, you'll see that he's got some sort of a ball hammer there that he's using to break up the curb. If any of you have a chance to, I would strongly recommend that you watch the movie Crip Camp on Netflix. And it talks about all the movement and protests that led up to the signing of Section 504. So there was a Rehabilitation Act in 1973 that was passed, and there was an amendment to it, which was Section 504, which was approved later after much protest, that basically said that for employment and for government, you could not discriminate against people with disabilities. So this is like legally, it's the precursor to the Americans with Disabilities Act. What you see on the left in that photo is you see what was called the Capitol Crawl, which was a protest in which people with disabilities left their wheelchairs and their assistive devices at the bottom, and they crawled up the Capitol steps to illustrate the need for access for those people. And on the right, you see a picture of Judith Heumann, who was the leader of the whole 504 movement that led up to Section 504. We're going to also make mention of Section 508 later in this talk, which is one that deals with procurement that's also an amendment to the same act. Here we see a protest that happened in Denver, where think of a time before we had kneeling buses and before we had any sort of accommodation to get somebody with a wheelchair inside of a bus. So this was a die-in or a sleep-in that was performed, to blockade buses on a very popular route to draw attention to the fact that public transportation definitely needed to be accessible for those people who needed it. And finally, we have the Americans with Disabilities Act, which is probably the most far-reaching piece of law that President Herbert Walker Bush approved in his administration. And this sets the foundation for architecture, for the sort of accommodations we have in law. And it's the precursor of where we should be with digital law. So let's go into detail. And so what's actually in the Americans with Disabilities Act? Well, there's a section of it that covers retail establishments, hotels, restaurants, anything that you would call a public accommodation. So any sort of public building or public transportation or an airport, a hospital, streets and sidewalks, all of that is covered under public accommodations. But there's also sections of the Americans with Disabilities Act that cover employment and say that you can't discriminate against somebody for a job on the basis of their employment. You also can't make the hiring process more difficult for somebody who has a disability. And there's also sections of it that lead to state and local government. So state and local government, learning institutions are affected by the first part, which is Title I. Employment is affected by Title II. And then we have Title III, which is the most important part of the ADA, which deals with public accommodations. So it affects the sorts of brick and mortar facilities that we were just talking about. And so it prohibits any sort of discrimination where you would build a facility that is not usable or not accessible to people with a disability. The tricky thing is 1990, when the ADA was written, was before the internet happened. We were just in the early days of electronic publishing. We're in the early days of having the internet, but not having the World Wide Web. So digital wasn't really at the forefront or wasn't really a consideration when the ADA was written. So what happens is we're taking what originally was written for bricks and mortar facilities, and in the courts, it's kind of being tested to see if that applies to the digital world. So increasingly, the answer is yes, it does apply to the digital world. So it affects, websites. And the first ones that were affected were websites that are linked to either a public building or a business that has bricks and mortar facilities. So now it's moved from that almost to any commercial website, and the ones that are the most suable, obviously, are the ones with the deepest pockets. So that affects the major brands. Title III also relates to educational materials, to the sort of software you use at the workplace, the software you use for hiring people, and then for other sorts of media like kiosks and native or mobile apps. Now, with the whole switch over to work from home, this has also exploded another whole issue in terms of your connection to your workplace. Your nexus is going to be online meetings, like Zoom here, or it's going to be through some sort of collaboration tools. And those tools also need to work for people with disabilities, or else you have the potential of an employee who can't actually work for you because the wrong tools are chosen. So that kind of opens up whole new areas of liability and exposure for corporations and whole new sort of frontiers to how the Americans with Disabilities Act should be applied. So in the next few months, or in the next couple years, during this administration, not a whole lot is going to happen. Now, one of the earliest executive orders that this administration signed was one saying that there were going to be no more regulations. And so if you decree that all websites have to be accessible, that's an additional regulation. So 2 other regulations would have to be scrapped to make room for this one, according to that executive order. So what's happened then, as a result, is that the executive or the Department of Justice is giving us no guidance when it comes to how the ADA applies to websites. So it's getting hashed out in the state courts and even more so in the federal courts. And most likely, there's going to be some sort of ruling in the next couple of years from the courts that says that Title III is going to apply to all websites. And for now, you have to be accessible or you're going to risk a lawsuit. So you may think that you might win a lawsuit, you may decide that you want to continue to be inaccessible, but the cost of taking that into litigation and defending yourself is much higher than probably making the changes to your website. The other thing is that kind of like the de facto standard that everybody is using is WCAG 2.0. And we'll get into that a little bit more in detail later on. So we also mentioned Section 508, and this is that Rehabilitation Act from 1973. And this is a federal procurement law. And basically it says that if you sell to the federal government, whatever you build needs to be accessible to all. And this applies to software as well. So Section 508 kind of affected software manufacturers earlier than Title III of the ADA. Now, one of the things that vendors do when they're proposing and bidding for federal government work is they have to fill out what you call a VPAT form, which is a voluntary procurement accessibility template. Now, a VPAT form will list everything that your software does and how it is accessible or inaccessible. So if you have a product like Zoom, you could go to the Zoom accessibility pages and you would probably find VPAT after VPAT for every product that Zoom offers. So one of the things that if you're evaluating software or if you're evaluating products, this is something you want to look for, because if a company has a VPAT statement posted on their website somewhere, not only are they aware of accessibility, but they're trying to meet pretty exacting government standards. When it comes to higher education, Section 508 also affects them. So if you have a major state university and that gets any kind of funding from the Department of Education, then it must abide by Section 508. So higher ed has been one of the biggest advocates of accessibility, because not being accessible becomes a massive, massive threat to their funding. So this is a very crucial issue for higher ed. So let's take a little break. We've got another different kind of law here, and this is the CVAA. And this was signed in 2010 under Obama, and it was set up to apply to online video. But the way it was written, the CVAA applies to everything that has an IP address. So let's jump ahead. It also specs out 10 performance objectives. So essentially, anything that has an IP address, according to the CVA, needs to work under these conditions. So it needs to work for somebody who has no hearing. It needs to work for somebody who has a prosthetic device or is wearing gloves. So for instance, on our cruise, in the cruise company, we had housekeeping apps. Those needed to work for people with gloves, because obviously you don't want people taking gloves off to be able to do housekeeping and then having to put them back on. So it also lists things like an app needs to be operable without vision, that is by a blind person, or with low vision and limited or no hearing, so they're able to magnify things, but they're not relying on a screen reader to read stuff for them. If you have a severe cognitive issue, you may need more time to perform things. So whatever app you build also needs to have a mode in which you can eliminate any sort of time-dependent controls on it. So these 10 things, I look at them as the 10 commandments for any sort of digital application that you would build. And these are pretty foundational. I was talking to one of the attorneys that helped draft the language for the CVAA about a year ago. And one of the things that she pointed out was that the CVAA was incredibly successful because it provided companies with safe harbor. So if you write a law, essentially what you want is you want to give corporations a guarantee, or give whatever entity a guarantee that if they do the right thing, they're not going to be sued and they're not going to be prosecuted. And unfortunately, where we are with web accessibility right now, we're not there. So whatever sort of laws need to happen or come up in the future for web accessibility need to provide some sort of safe harbor for people who are building websites or people who are building digital experiences. So if you meet a particular standard, then that moots any sort of lawsuit that may be brought against you. You don't have to defend yourself and prove it. So safe harbor is an incredibly important concept on the defendant side. Many of you guys probably haven't heard of the Unruh Act, which is in California. So just like you have emissions controls and you have a certain level of emissions that is acceptable under federal law, Californians have much tighter emission standards, and because they have a stricter standard and people want to do business with California, that becomes a global standard. It helps to be the 5th largest economy in the world that way. So the same is true for websites. And the same is true for disability laws. So the Unruh Act is much, much stricter than the ADA. A friend of mine describes them as the ADA on steroids. And it offers penalties of $4,000 per violation. The question is, if you have a website, how do you count the violations? Is it every page that is in violation? Is it every page view or every unique visit to your website? Is it every instance of a missing piece of alternative text? That's something that still has to be hashed out in the courts. But the Unruh Act also has a sort of standard which is unique, in which a plaintiff doesn't have to prove damages. So if I'm a blind person in California and I'm trying to use a website and it's inaccessible, I don't have to prove that I was somehow damaged by not being able to use that website. I don't have to prove, for instance, the value of the job I didn't get. All I have to do is prove that that site is inaccessible under the Unruh Act. So we've covered the Unruh Act, we've covered the CVAA, we've covered the ADA, we've talked about Section 504 and Section 508. Now, in all of this, what's missing is legislation that is specific to digital accessibility. So we're kind of in the position where if we take it to the courts, it's being decided in a bench trial by a judge. So a judge is going to be listening to expert witnesses from both sides and trying to make the best argument that she or he can. Now, if you were doing this through Congress, you'd write up a bill, you'd have a committee, there would probably be a congressional study, and there would probably be a whole lot more research and analysis done to this than if you were in a court setting. So ideally, we would have some sort of legislation that would protect digital accessibility. In the absence of that, we would have some sort of ruling from the Department of Justice. And again, Justice would probably perform some sort of research or some sort of analysis. So, and it would not be left to one single person hearing arguments by highly paid expert witnesses. So if you're sued for not having web accessibility, what you have to understand is that is a civil rights lawsuit. It's the same as a discrimination lawsuit. So not having access in the courts is considered discrimination. So 60 years ago, you could have a sign like this in front of a shop that says, "We cater to the white trade only." And in certain parts of the country, this was so common that nobody would think twice about it. The issue that we have now is that digital accessibility issues are so commonplace, again, that nobody thinks twice about it and nobody, gives it a second thought. There was a study performed by WebAIM in Utah, and they looked at the 1 million most frequented homepages, and they found that 98% of websites have detectable issues that would affect the accessibility of that page. And as pages grow larger and more complex, the prevalence of those issues is getting higher. So they've had 3 successive studies in the last year and a half. Each study is actually showing that this percentage is increasing. Like, you're at 98%, you think, how much higher could this go? And it gains by a couple tenths of a percent every single time they run the study. So what are some everyday forms of discrimination you would see? If you have a banner ad that doesn't have alternative text, that's an offer that somebody can't see. If you have a shopping cart that you can't work, that's a purchase that you can't make. If you are using a reservation engine for a hotel, chances are you can't book a reservation if you're blind. The airline industry, they've had their own laws that apply to them, the Air Carrier Access Act, and those are extremely strict. So actually, airline sites are probably among the most accessible sites that you'll find out there. You have apps that you can't use. Another problem that you may have is that if your website is unusable, but you offer an 800 number, that 800 number may only be available during certain business hours. So that's discrimination, because you're not offering people with a disability the same convenience that you would offer them if they were fully able to use the website. So these are all different everyday forms of discrimination or everyday barriers that people with disabilities encounter when they're trying to use digital products. We tend to consider people with disabilities as edge cases. And I've heard this on projects, hey, accessibility is not in our budget. It's not a priority. Or we'll get to it because we've got all these other issues we need to handle first. Or I've heard, blind people don't use our fill in the blank app, product, what have you. or that it's not MVP. But these are things that I personally have heard in my career, and I would probably still hear tomorrow if I were in a business meeting. But again, you could solve certain amounts, a certain portion of your accessibility issues, but unless you have a digital experience that's accessible from end to end, you're going to end up in a scenario like this, where you've got half a ramp to nowhere, and you've got an end product that's just as unusable than as if you had taken no trouble with your accessibility efforts. So how does this happen in the courts? What sort of cases are there? Now, it should come as no surprise that because we have the Unruh Act, that California is one of the states where the most legal action happens. New York is another one, and also here in the 11th Southern District Court in Florida. So some of the cases, some of the landmark cases for accessibility have happened here in South Florida, in Fort Lauderdale, and in Miami. There's been this massive jump in the amounts of cases that have been filed in federal court. From 2017 to 2018, the number of cases almost tripled. And people were getting actually very anxious because if it kept on spiking up at the same rate, the federal courts were going to be absolutely flooded and with nothing but web accessibility lawsuits. Fortunately for us, they've kind of leveled off between 2018 and 2019. And, it's anybody's guess as to, what's happening now with everybody working from home, in terms of how much easier is it to actually file a lawsuit in a courthouse. I would imagine it depends on the digital availability of that courthouse. So one of the things to know is that almost every single one of these lawsuits gets settled quietly and it doesn't go to trial. I mean, the amount of damage it could do to your brand would be enormous, and the cost is ridiculous. So if you look at 2,235 cases, probably 2,230 have been settled. So there are some law firms that are incredibly active when it comes to filing lawsuits. The top one is Cohen and Mizrahi out of Brooklyn, New York. In 2018, they filed 372 cases. Last year, the caseload was about 1 hour that were being submitted to federal courts. So these, the top 20 firms, so these plus a couple that didn't quite make it into the list here, accounted for 87% of the accessibility lawsuits that were filed. They're mostly search and replace cases or lawsuits, because attorneys don't like spending a lot of time writing a case from scratch. So they'll go and look at what's out there, who's won, and they're going to model their case after one that's already been written. So it's pretty easy to start finding patterns in the lawsuits and in the settlements. So one of my favorites to look at is Mendez v. Apple, because it was published in a newspaper, and so you can actually access Mendez v. Apple and read it for yourself fairly easily. And it is public knowledge. And I have seen countless cases that are modeled after this one. You look at them and you go, oh, I know this. Okay, it has the same 17 major accessibility issues. It's claiming the same 4 default issues. It has the same language. So it gets copied over and over again, not just by the same firm, but by other firms against other defendants. If we look, you'll find different issues. These are the 4 major issues: missing alternative text, empty links that contain no text, linked images missing all text. These are totally like low-hanging fruit that if you do any sort of quality control, like you should be checking for this just the same way that you would run spell check. It's just basic quality control. And yet, these guys with 98% of the websites having accessibility issues could just issue these lawsuits without even having to check the website first. I mean, that's how ridiculous you could get. It's like you throw a stone and you're going to hit something. So what goes into a settlement? So typically you're going to see like these same elements in every website accessibility settlement. You're going to pay some sort of monetary settlement, and that's like in the 4 or 5 figures. That's the least of your worries. How much you're paying your blind plaintiff for the lawsuit, that's the least of your worries. Then you're also having to pay some sort of monetary settlement to pay for attorney's fees and expert fees. That's significantly more. But again, that's likely, maybe about $100,000. Then you have your own internal costs of having your own legal counsel working on the case, hiring an outside legal counsel. So once you get into all of this, you've probably got about $350,000 in to defend yourself and get to that settlement if you're a large plaintiff, if you're a large defendant, sorry. So you promise to pay the monetary settlement. You promise that you're going to fix your accessibility issues within a certain time frame. Usually it's 6 months, or it could be 1 year. If you're a really large company, you may be able to buy 2 years to be able to fix your accessibility issues and hit a certain standard. The settlement's going to say you need to hire accessibility experts. So chances are you're either going to bring somebody in-house full-time, or you're going to hire somebody from the big accessibility consulting firms. These guys are growing fantastically. Even in spite of this big recession that we have, they're still hiring. So there is enough work to go around for those accessibility experts. The other thing is you're going to train your web and mobile staff. And finally, one of the things that you're going to do is you're going to publish an accessibility policy. So you're going to publish a statement on your website that says, we, blah, 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 are highly committed to improving the user experience for people with disabilities. And publishing that policy usually reflects some sort of real commitment from top management. So that's oftentimes the biggest hurdle to getting that policy published on the website, is more you have to get that buy-in from top management. Domino's is an incredibly important case because in this case, the way it played itself out is that a blind man found it impossible to order a pizza online. So he happened to be in California, so he filed in the 9th District. Domino's, instead of settling this or trying to accommodate him in any way, they chose to take this to trial. They felt very strongly that Title III did not apply to them because they're a digital business. The case got dismissed because the judge in the federal court said, well, I don't have DOJ guidance. I don't really want to hear this case. So then it went to appeal. They lost in appellate court. And then Domino's appealed again to the US Supreme Court, which decided they don't want to hear the case. They didn't feel like the case was important enough to be heard by the Supreme Court in this season's cases. And so it got remanded back to the 9th District. So now the judge in the 9th District, who didn't want to try it originally, now has to try it. So the stakes are, does Title III apply to a website? It's proven, because it came back to the 9th Court, that lack of Department of Justice regulations, it's not a blocker for hearing the case. And it was going to be heard, and we're still waiting to see how it plays out in the 9th District Court. Now, in all of this, Domino's could still settle, but they're still refusing to settle. They're producing more digital content, more digital experiences, including an app for ordering, and it's anybody's guess as to how accessible that app is. So we have one case that was tried down here locally. This is Gill v. Winn-Dixie, a blind gentleman from Coral Gables who couldn't do a number of things on the website. He couldn't use coupons. He couldn't fill online prescriptions. And, it may not seem like a big deal, but for somebody who's blind and having to go to the drugstore, the pharmacy inside of Publix, you never know who's around you listening to you. So you have no idea how much privacy you have if you're blind and in a public setting. So the other thing is being able to do your shopping. You don't want to have to be asking the store personnel to tell you what's on the shelf all the time. So you could find that annoying. So a website starts filling in all these sort of functions that become more tedious or more difficult or less private in the physical world. One of the things about this case is that Winn-Dixie, they used third-party software. They said, hey, you can't sue us because somebody else built this stuff. And Judge Scola, who heard the case, decided, no, this does apply to your website because you're responsible for your third-party software, because you're responsible for vetting who you hire and which vendors you get. So this is significant too, because of all the cases that are out there that went to federal court, this is the one and only case that has gone to trial and has had a bench decision on it. So this is the only case where a judge has ruled on it and has written something. We have this other case, Thurston v. Midvale, which happened in California, and this is the Unruh Act that I was telling you about. And this is a restaurant that uses OpenTable. Blind woman from LA can't use the website to make reservations. What they found is in discovery, they found that the chief marketing officer for the restaurant chain had not even bothered to research, what sort of accessible reservation tools were out there. He just decided to use OpenTable. The judge, again, found the restaurant to be liable because they hadn't vetted their options. But it never even went to trial. What happened is that the judge dismissed it with a summary judgment, said, okay, just based on what I'm seeing here, I'm going to judge this without a trial, with prejudice, and be like, no, I find for the plaintiff here, and the restaurant is guilty of discriminating. This was, I think, 1 or 2 years ago. I believe the restaurant is shut down and it doesn't exist anymore. So one of the other things that came out of this particular case is that the whole thing about an 800 number not being an equivalent to a website, unless you had people willing to take phone calls 24/7 and provide an equivalent level of service. Another thing that came up from this is that WCAG was the standard that you need to live up to. So let's talk about what WCAG is and what these different guidelines are. So WCAG is a set of 60 to 100, I believe there's 69 different success criteria in WCAG. Oh. And so what it does is it tells you, it specifies standards that your digital product needs to live up to. Like it needs to have alternative text for non-text content. It needs to be operable in different conditions, just like we saw with the performance objectives from the CVAA. WCAG goes by 4 principles, and when we get into testing the next time, these 4 principles you're going to see how they're applied. So perceivable means like, hey, can I see the content? So if you have an image, a banner ad, and you don't have alternative text, the screen reader that a blind person uses has nothing to read. So that element is not perceivable. If you have video and you don't have captions to it, then to a deaf person, that video is not perceivable. The next up is operable, which is, can I work the forms? Can I work the widgets? Can I work the components, the controls that are on that page? So that's a standard that sites and digital products need to live up to. And operability is usually something that you have to test by hand. It's not something that you can test with automated tools. Is it understandable? For those of you who are in UX, you're going to get this because it's essentially, is it usable? Do I know what I need to do at a given point in this user experience? And then finally, is it robust? Which means, does it degrade nicely? Does it work in all circumstances? There's 3 levels to WCAG. There's A, which is like, obvious, like, hey, this absolutely needs to happen to be even minimally accessible. There's AAA, which you need On the other hand, when, for instance, you're talking about something where it would be catastrophic for somebody with a disability not to get that content. So think of an Amber Alert or a hurricane warning, or being able to use a hospital website, or being able to use a government's website. So those need to live up to the AAA standard. And kind of in the middle is a sort of Goldilocks standard, which is AA. And the AA is really the one that's used almost universally as a legal standard. So if you care about getting sued or not, then really AA is the standard that you need to live up to, and you can ignore the other two. The other thing is that anything that is in the A standard is also included. It's a subset of what is in the AA standard. So each one kind of encompasses a standard that's lower. Lots of accessibility mistakes. We talked about alt text. We talked about things like empty links and stuff. These I would like to go into more detail because we're running a little bit long. I'd like to go into more detail next time when we start doing testing, and we can go into how you test for all of these and how these mistakes manifest themselves on a site. So one of the things I mentioned in the previous to this was that we're going to talk a little bit about the trolls. So Sherry Byrne-Haber, she's a colleague of mine who works as the head of accessibility for VMware. She is a very, very prolific blogger, and she's probably one of the premier experts in terms of how accessibility laws apply to websites. So hers is a blog that I would highly recommend for you folks to follow, and it's very entertaining. So here in Miami, we have probably one of the most prolific lawyers back in 2018. Well, he is no longer allowed to practice, he's no longer allowed to file an ADA lawsuit unless he has explicit permission from the Florida courts. So basically, he and various plaintiffs with different kinds of disabilities went and sued most of the cities and towns in Central Florida for their websites not being accessible. So a lot of towns would have, for instance, a PDF talking about garbage collection that wasn't accessible. They'd be sued for that. So imagine if there was any flaw to these websites, there would likely be an accessibility lawsuit against them. So what ended up happening is a lot of the cities and towns ended up kind of scaling back their websites as a result of all these sort of serial lawsuits. What got Scott Dinnan in trouble was the fact that he went around suing gas stations for having video. Now, those sort of videos that come up, and they're kind of annoying when you're trying to pump your gas and they're trying to get your attention, like, hey, look at me, The issue was that they had video and they didn't have captions. And the solution, which was really simple, was like, well, you just turn off the video and then you're no longer in violation. They knew this, but they didn't reveal that to the gas stations. So it wasn't about remediating a situation. The spirit was more in terms of how do we actually make money by generating these lawsuits against the gas stations. So in his career, he's filed over 650 ADA cases. Some of the stuff that got him in trouble was the fact that he billed himself, on one hand, as a $500 an hour expert, but when he found himself getting in trouble with the court, he's like, oh, well, I'm just making mistakes because I'm a legal novice. So you can't have it both ways. You can't be an expert, you can't be a novice at the same time. So the court found this and all kinds of other unethical behavior that he performed. I'd actually say, like, of the legal cases that you can read on the ADA, this one, if you can get the judge's ruling, is actually pretty entertaining. So I'm going to leave you guys with a few recommendations to basically protect yourself from getting sued. Number one is check your code. I mean, you can use a tool like Axe or Wave. You can use it like spell check. You'll find you'll find the detectable accessibility issues. And guess what? If somebody like Scott Denon is coming after you or your company, it's going to be because they're using they're using tools like this as well. So if you can do automated testing, check your code, ideally check it while you're in development before you commit it, before you have to go and change stuff, like highly, highly recommend. So that's number one. If you spot an issue, fix it. So if you get, for instance, a free risk assessment and they find issues and they give you a report on what's wrong with your website and you don't fix it, and then you get sued, this is something that could be subpoenaed, and this is a paper trail that essentially would be the smoking gun to say like, whoa, you're aware of these accessibility issues, you didn't fix them. Judges don't take very kindly to that. So those of you who use WordPress or another CMS, save yourself a lot of grief on the front end by starting with a theming framework that is accessible. So if you start with something, you don't vet it for accessibility, and then you're thinking, let me build something and kind of fix the accessibility, at the very end, you're causing yourself a ton of grief. So essentially, find something, a good core product that you can work with that's very accessible, and then make sure that you start with that clean code and try to keep it clean as you're testing as you go. I should even say this, test all third-party products, your shopping cart, your e-commerce platform, your media player, your sign-up form, your reservation system. If there's anything we should learn from the sort of cases that we've seen today, is that all of your third-party products should be tested and clean as well. A lot of firms will offer you an accessibility overlay, which is kind of like this JavaScript that looks at your code, looks for commonly detected issues, and then fixes it magically. Now, one of the issues is that you can't find all your issues that you might have with automated testing. So an overlay can only find what you could find automatically. The other thing is that you're not really fixing the issue. At best, you're putting a Band-Aid on it, so you're trying to mask it and get it past something. Whether you're trying to sell it to the government or you're trying to bring your errors down really quickly so it looks like you're doing something because you're being sued and you want to look better for the judge. But you're going to find yourself in a position where you're continuing to pay for this overlay service, and at the same time, that's going to take budget away from the real accessibility issues that you're going to want to be doing behind this. And yes, please, use alt text already. If you have an image, add a description to it. Don't use the automatically generated ones because those are just awful. And the same thing goes with captions on your videos. Just make sure the stuff is accessible. And this is not that hard to do, people. I mentioned captions. And finally, don't try to be the expert. If you get sued, if you get hit with an accessibility lawsuit, do not try to handle that correspondence with a plaintiff on your own. Get decent legal counsel. It's out there. If you need to make fixes, and you're a large enough brand and you're in trouble, hire an expert. There's one case that was tried in Ohio where the IT director billed himself as the expert, even though he knew nothing about accessibility. The company presented him as an expert witness, and the judge was totally insulted, and essentially that was another one of those cases that didn't go through a full trial. The judge just basically decided that with prejudice. So thank you guys very much for joining me tonight. Next time we'll be talking about accessibility testing and how we can take some of this legal knowledge and put it to practical use. And I'm going to take a little sip of water. And Jonathan, I'm going to let you help me out with the questions and stuff.
Yeah. All right. So I'm going to unmute everyone. But if you came up with any questions, hopefully you guys were jotting down some notes as he was speaking. Now's your time to speak up. I'm going to unmute you guys so you can go ahead and talk and fire away. And it should have unmuted you.
I'm looking through chat right now. I don't see any questions in there. I see a lot of highs. Hey, everybody.
So, hi, everyone. My name is Ryan Lee. I have a question. So, I wanted to know for the Unroot Act, would it
Right.
would it apply to other states, like specifically if there's plaintiffs in another state filing, like, or bringing a case against a California business?
So that's a really good question. So no, if I were a Florida plaintiff, I would not be able to use the Unruh Act in a Florida court. That's a California law. But on the other hand, if I'm a major brand, I can't build a website that stops at the California border. So if what you run into is you're going to be tried by you're going to be hit with a lawsuit from a California attorney that's found a disabled plaintiff within the state of California. That's the standing you need.
Oh, okay. I understand. So
There's
within the scope of California.
Right. There are other cases that have happened, for instance, where like there's a case against Kroger, a chain of grocery stores in Ohio, where the plaintiff was in New York. They were nowhere within the area where those stores existed, and they were suing that the website was inaccessible. So the judge in that case felt that they didn't have standing because there's no way they could be shopping at Kroger, and so there wasn't a case. There's another one with a local credit union that kind of followed the same guideline. Unruh is a lot less strict in terms of the sort of standards, of where the bar is set for you to prove what standing is.
Yeah, perfect. Thank you, Claudia.
Any other questions? Man, I know this is a mouthful. This is usually a topic that's not really discussed in our community too often. So I'm glad you guys joined and heard this out, because even for me, I'm just like, what? And not that I have all the experience in the world in UX, but still, like, this is valuable information, and it takes a little bit of while to digest. And if you guys do have any questions, speak now. If not, you can always connect with us offline on LinkedIn, Instagram, wherever you can find us. Yeah. Anyone else have any questions?
So we'll have a recording of this posted later on, and Jonathan's been really great about putting together talking points and takeaways. So hopefully we'll have one of those out in the next few days as well.
Yeah.
Awesome. So I think with that, there's a couple of things I want to just go over, more housekeeping items. And as Jonathan and Claudia mentioned, I think there's a lot of stuff that's going to be coming down in terms of capturing all of this content. But I think what's really important as we go through this process is really, I think, setting up the tone for the next couple of weeks. I know, Claudia, there's some events going on. We're going to be actually planning our next IXDA event, probably also focus beyond accessibility. We're doing a couple of things of ways of supporting the UX community. If you guys remember from our last time, I think we had a couple of areas. Do you guys hear an echo with me?
You just suddenly got an echo, sorry.
Got it, okay. Give me a second. How's that? Better?
Better.
Okay, perfect. So really, I think what's going to be happening over the next few weeks, and I know we have kind of a mixed group here between everyone from UX, research, and so forth. So we're going to be doing a couple of talks, and our next series, right, Beyond Accessibility, is going to be around UX in the era of COVID. And so I know that there's a lot of people that are kind of going through that process right now, whether that's working from home or doing, whatever remote work we can, or if you're looking for a job, right, if you're looking for ways of staying relevant or adding value, please feel free to reach out, right, to Jonathan, myself. We're going to be putting together a couple of resources around that as well. And I think building on everything else that we have right now, you guys probably saw the email that went out today, which is really, we look at accessibility from a context of, not getting sued or understanding ultimately how you can go through all this process. But I think one thing that's really important is that this is a huge opportunity, right, for everyone. So either you understand how it works, and I think today, Claudia, like as always, right? You put a clinic with with all the content. It's like taking a drink out of a fire hydrant, with everything that we have to go through. But I think what's important is that there's going to be a lot of these disciplines, and I think in many ways, as business are forced to go online, there's a lot more opportunities for these lawsuits to kind of take hold. And we know that there's quite a few in South Florida, but there's also the opportunity for us as designers and creatives and from a user experience standpoint to add value. Just based on what you learned today, right? Just from all the stuff that we kind of went through between the last meetup that we had and today, it's easy to basically go through that process and add value to a company, right? I think a lot of time, both Claudio, Jonathan, Marcelo, we've been discussing areas that we can actually have, ways that we can actually not just have these meetups for the sake of, gaining knowledge, but for the sake of helping the community. And so I hope, obviously, with, all the content that we saw today, hopefully your brain's kind of going in ways that just like, how can I use this in my business? How can I use this, to get a new freelance gig? Or how can I use this to either advance my career right now, with the company, there may be some uncertainty. So we'll definitely kind of open it up for you guys to have, hey, if there's challenges that you're going through right now, if there's content or areas that you would like to see in the coming weeks, especially in this time of, everyone being quarantined or there's a certain level of uncertainty, we're going to be basically supporting those efforts. But again, right, as I mentioned from the beginning, this is really meant to be a community initiative. And I know, Claudia, you and I had talked a little bit about setting up even some office hours. So if that's something that you guys think would be valuable beyond just our weekly meetups, either say yay or put a little thumbs up or something in the chat. I think what's going to be really important for us as we move forward, in the next 3, 4, 5 weeks, who knows how long this may take, right, or longer, is to make sure that not only that we remain connected as a community, but really as a way of supporting each other, right, and ways that we can collaborate in those efforts. And so with that, Claudio, I know you had a couple of events that are coming up. I'm not sure if you want to just kind of close with that. And again, as we mentioned, we'll go ahead and get this out to you guys, and we'll be basically following up with the next series that we're kicking off around UX in the era of COVID.
Okay. So again, the next event that I'm going to be presenting will be on the 14th, and we're going to be talking about testing. And that should be a good one because that should be stuff that you can really apply practically, right away to your own work. The other thing that I have is at the end of this deck, like the end of all decks that I have, I usually try to put a link to different resources. So I have a link to my friend Sherry's blog on Medium. Also, a couple different newsletters and blogs that you should follow. Like this one by Jack McElhaney is excellent if you really want to keep up with accessibility law. WCAG website, it's a fantastic reference. Probably not the most exciting reading out there, but definitely I would recommend follow Sherry and sign up for the newsletter. Seyfarth Shaw is a law firm that handles that does, I don't know if they handle a lot of the cases, but they are watching and they're published quite a bit in terms of the state of the law with accessibility. So I would certainly encourage you to follow their ADA Title III blog. So this is up on SlideShare. So if you find me, Claudio Luis Vera, on SlideShare, then you should be able to see this. This will be the latest presentation that's up there.
Awesome. Well, Claudio, thank you so much as always. You crushed
Thank
it.
you.
There's so much stuff to kind of go through here, and I'm glad, Jonathan and I will probably have our work cut out for us over the next few days or so just to getting everything out. But thank you, everyone. Again, we'll be available either through a lot of our channels on Meetup. We'll also be connected on LinkedIn if you haven't friended myself, Claudio, or Jonathan. We'll probably be posting a lot of these updates through there, so make sure to do that. And we'll see you guys on the next one, okay? Talk to you soon.